So we are going to go ahead and begin our expert panel conversation now. We have a few folks on the phone. There they are. So we will go ahead and do a quick round of introductions from our guests on the phone. We're going to start with Councilmember Rice. So Councilmember Rice, why don't you go ahead and introduce yourself first, and then walk us through your remarks, and then we'll continue through the line of our other special guest, which is the Federal Elections Commission Commissioner Weintraub, and then we also have Professor Coates. So please, Councilmember Rice, thank you so much for joining us and for the work that you did in St. Pete. And just got to make sure that you are unmuted so we can hear you. There you are. We can hear you now.
Thank you. Thank you so much, Chairwoman Gonzalez, for this opportunity, and congratulations and hello to Councilmember-elect Peterson. And I'd like to say hello to other people who are calling in and sitting at the table. Many of you are people who we worked with before here in St. Petersburg, and it's nice to see the familiar faces. I'm Darden Rice. I am on my midway through my second term on City Council at the City of St. Petersburg in Florida. What I will be talking about today is our efforts and the year-and-a-half effort that we went through to ultimately pass our ordinance, which is very similar to the one that you're looking at today. So I look forward to, after we go through the round of introductions, talking about what we did here in St. Pete and answering any questions about our experience with our own anti-super PAC campaign finance reform ordinance.
Hi. Would you like me to just introduce myself, or do you want my opening statement now?
Let's do an introduction.
She didn't hear you.
My name's Ellen Weintraub. I'm the chair of the Federal Election Commission.
And maybe just to complete the introductions, I'm Professor John Coates at Harvard Law School, and have focused on corporate law principally in my career, and I've only in the last 10 or 15 years been sort of dragged somewhat reluctantly into Commissioner Weintraub's world because corporations used to be relatively reluctant to enter into campaign finance. They, as you know, are increasingly, unfortunately, active. And so the intersection of the two worlds is where I find myself increasingly. So happy to be here. Thank you for inviting me.
Okay, and then we want to do one last introduction. Did Commissioner Weintraub already go? Okay, sorry. I had to step out for just a moment. So we'll go back to Councilmember Rice so that we can hear from you, Councilmember, on your experiences leading this effort in St. Pete. Take it away.
Great. All right, thank you so much. So for those of you, just for a little bit of background, St. Petersburg is on the west coast of Florida. We are sort of a sister city to Tampa and part of the Tampa Bay region. We're the 5th largest city in Florida. We have a population of 260,000. A lot of people describe us that St. Pete is to Florida like Austin is to Texas. We have a strong mayor form of government, and we have 8 city council members, each of us who have our individual districts that we take residence in, but we're all elected in the citywide general election. Prior to getting elected to council back in 2013, I was the president of the League of Women Voters of St. Petersburg and held that position for a number of years. So I bring a pretty strong background and solid commitment to good government issues, fair and clean elections, voter protection, voter registration, and citizen public engagement. So I came into office as a pretty strong, your basic good democracy nerd. One of the first things I started working on was actually to reduce the maximum contribution cap, which was state law at the time. The state of Florida had allowed the maximum contribution to local elections be increased from $500 to $1,000 per entity. I thought it was a pretty modest reform to propose that we actually pull that back down to $500, to a $500 cap. We also looked at issues such as different types of public financing of elections and our own voucher program. And unfortunately, although all of these ideas were politely received, they died on the vine, and it was difficult for me to get the majority support I needed from my colleagues. They weren't stirred to action because the feeling was that what would be the point of enacting any of these local measures if it was so easy for someone to just simply go around those local laws and contribute unlimited amounts to a super PAC. So I gave that a lot of thought, and we ended up coming back later with this, with our ordinance to address the influence of big money and super PACs in local elections. In August 2014, our council unanimously supported a resolution to support Move to Amend, and that was an opportunity for us to express our values about the way we felt about our position on Citizens United and big money in politics. And this resolution ultimately is a very effective organizing tool. I was able to later work with the same group of people who brought the resolution to us, and this same group of community leaders also connected me to the great people at Free Speech for People. And Free Speech for People was definitely aligned with the people in my community, the League of Women Voters, myself, on what we wanted to do for campaign finance reform. And they helped provide invaluable assistance in crafting a legally sound ordinance, as well as connecting us to subject matter experts, some of the best legal minds in the country, and indeed many of the people that you have there with you today to help us answer any questions that we had about the process of passing this ordinance. So we spent about 15 months deliberating this ordinance. We had multiple meetings, 2 committee of the wholes, 2 public hearings, a number of community-wide panel discussions, including a panel discussion at our local law school. We had a group of our citizens, just dozens of citizens that came in to speak at open forum to express support for the bill and why. And we were joined by very strong community support organized by our neighborhood associations, the League of Women Voters, SEIU, a number of environmental organizations, and social service organizations. In St. Pete's case, we passed our ordinance prophylactically. We saw the threat that super PACs and the corruption of big money was bringing to the national and the state level. And we just thought it was really a matter of time before it was going to land at our door. So we thought it was prudent to take proactive measures to keep big money out of our local elections. In fact, at the very same time that our council was deliberating on fingerprint background checks for Uber drivers, Uber was putting $9 million into a referendum in Austin, Texas to overturn almost the same exact ordinance that the Austin City Council had passed. So, and as we worked with our community, it was very clear that from every corner of the community, people expressed to us that we didn't want our housing regulations to be written by Airbnb. We didn't want our public safety laws to be written by Uber or for the NRA for that matter. And we didn't want our some of our tools to address affordable housing, such as inclusionary zoning, to be kind of wiped out by the influence of the realtors organization. We also depend on tourism. We don't have a state income tax, so we definitely don't want to see the fossil fuel industry writing the laws that protect us and protect our clean shores from the threat of offshore oil drilling. So it was clear that there were loopholes in the federal laws that enabled us to fully protect ourselves from the influence of big money if we did not write this ordinance. And luckily, a majority of my colleagues and I saw that one of the best ways to protect ourselves was to really step forward and lead the way with being one of the first municipalities to write a ordinance like this. We feel like we're on pretty good grounds, constitutionally speaking. The $5,000 limit from corporations is commensurate with other federal case law, and the law on forbidding money from foreign nationals is not complicated and it's pretty straightforward. So requiring that any corporation that gives over $5,000 to a PAC must affirm that there's a very low threshold of foreign nationals on their board seems pretty reasonable, and we're confident that this is a constitutional ordinance that we are happy to defend, and we will defend. The ordinance was passed 2 years ago. After it went into effect, we've only had one local election take place, and that was our city council election that took place at the same time as yours last November. It's an off-year election. There were 4 odd-number city council districts up for re-election, and we did not see any activity of anyone trying to go over the $5,000 limit. We have not been sued or challenged and have not received any official questions challenging this. It may come up perhaps in a couple of years. We're going to have a mayoral election in 2021, and it's certainly going to be a high-profile election. And that might be a time where we might see some sort of opposition, but so far it's been pretty quiet, and we've had strong support from our mayor and from our community at large.
Great, thank you.
I'm happy to answer any questions.
Thank you so much, Councilmember Rice. Really appreciate you taking the time this morning for us and early afternoon, I believe, for yourself to join us via video to walk us through your all's experience as being the first city in the nation to pass a very similar ordinance. Really appreciate all of your work and your accessibility to me and my staff as we have been deliberating this issue and looking at it over the many past several months. So I want to provide my colleagues an opportunity. I want to recognize that Councilmember O'Brien has joined us at the table. He sat as far away from us as he possibly could. I will not be personally offended. But colleagues, any questions or comments for Councilmember Rice? Councilmember Bagshaw.
Thank you. Councilmember Rice, thank you so much for all your work. Thank you for weighing in and being part of it today. I appreciate it. I'm Sally Bagshaw. I am one of the council members who has been here for 10 years, and I've got about another week to go. So I am here in support of Councilmember Gonzalez, and really appreciate everybody here who's at the table. A question I have, and I have to smile because when you started listing off the companies, whether it's Uber or the oil companies or the Airbnb issues, all of these we're dealing with as well. Do you have any advice as far as how, as a community, you got the word out, got support for your, what did you say, 260,000 population, to get the full support that you did, no lawsuits, at least on this first year with the first campaigns?
Yes, that is a great question, Commissioner. I think that one of the things that was really going for us is the public is not in support of this type of influence of big money in elections. We've seen the impact that this has on the federal level and on the state level, and we certainly didn't want to see it. We didn't want to see our city become a playground for super PACs. And so I think that message was very strong. We worked with a great team of people that were, I think, very smart at showing how some of the super PAC activity impacted us on the local level. And I think people, and then certainly there's liberal super PACs, there's conservative super PACs, but I think on the local level, people really did not like the idea of corporations having such strong influence with maybe even picking the representatives who sit at the table, much less writing our laws. So that seemed to have a very strong appeal in St. Petersburg. I will tell you that when this discussion first started, I did have a lot of pushback from our legal staff. And St. Pete has a great legal team, but we are a mid-sized city, and our attorneys are hardwired to keep us from doing anything that might get us sued. And we don't have the same level of expertise, and I don't think anybody would expect a city to have attorneys on staff who are constitutional and election law experts. And that's why working with Free Speech for People was so effective, because it really helped us bring that expertise into the room. Once we had the mayor on board, it helped us work a little bit more with our legal team and encouraging them to be more solution-oriented and to be problem solvers rather than just putting obstacles in our way and putting the fear of God in our minds about getting sued. It really came down to the fact that my colleagues stood up and said that we can't be stopped from doing what's the right thing to do because we're afraid of being sued. And I think that type of courage and commitment is what won the day.
Well done. Thank you for that.
Great. Thank you. Any colleagues, any other questions from you for Councilmember Rice? Okay, well, it looks like that is all of the questions from our council members here at the table. Councilmember Rice, I know that you have other obligations, so we will say goodbye to you at this point for now. Look forward to staying engaged with you over the next several weeks as we continue to work on our legislation, but really have truly appreciated your perspective and your guidance and your counsel as we continue to deliberate through this, and really appreciate you taking the time out of your busy schedule to join us. So greetings to you and to all of your constituents in St. Petersburg, and thank you so much for all the work that you've done in this space.
Thank you. I look forward to working with you, and I'll be talking to you soon.
Yes. Bye-bye. Okay, we're going to go ahead and move through the rest of our panel. We are now going to hear from Chair Weintraub and Professor Coates, specifically on the issues related to foreign influence and corporate thresholds in policymaking. And I'll go ahead and hand it over to you folks to lead us through the conversation on this particular piece. And I believe, Chair Weintraub, are you gonna kick us off?
I believe so.
Great. Take it away,
Good morning.
please. Good morning.
Madam Chairwoman, members of the committee, thank you for this opportunity to testify regarding this proposed ordinance. The Seattle City Council is widely renowned for its leadership on campaign finance reform issues. I am a particularly big fan of your democracy vouchers, one of the most exciting reforms to emerge anywhere in the country in the past few years. I want to focus my remarks on the provisions that would require a corporation seeking to influence Seattle's elections to certify that it is not what the ordinance terms a foreign influenced corporation. I want to assure you today that while the foreign influence provisions you are considering will build upon your leading edge reputation for campaign finance reform, these proposed provisions nonetheless fit comfortably within existing federal statutory law and Supreme Court precedent. What you are considering here is the sort of reform that may only succeed at the local and state levels at the moment, as ideological opposition to campaign finance law enforcement has effectively paralyzed both the Federal Election Commission and Congress. Fortunately, state and local governments across the country are stepping into the breach and leading the way with innovative solutions to campaign finance problems. The provisions you are considering are consistent with an approach I laid out in an op-ed for the New York Times that described a new way to read the Citizens United decision together with the foreign national political spending ban. In a nutshell, I noted that since the Citizens United majority protected the First Amendment rights of corporations as, quote, associations of citizens, and held that a corporation's right to participate in elections flows from the collected rights of its individual shareholders to participate, it follows that the limit on the rights of a corporation's shareholders must also flow to the corporation. And one of the most important campaign finance limits we have is that foreign nationals are absolutely barred from spending directly or indirectly in U.S. elections at any political level, federal, state, or city. It thus defies logic to allow groups of foreign nationals or foreign nationals in combination with American citizens to fund political spending through corporations. You cannot have a right collectively that you do not have individually. Accordingly, the proposed ordinance seeks to ensure that only those corporations owned and influenced by people who have the right to participate in your elections are doing so. 2 years ago, I was pleased to support St. Petersburg City Council member Darden Rice in her efforts to pass this approach into law in her city, and I am delighted that she was able to illuminate your discussion today. Seattle's adoption of this very similar measure would give major momentum to this fresh approach to corporate political spending. The heart of your proposed ordinance definition of a foreign influence corporation is 1% ownership by one foreign owner or 5% ownership by more than one foreign owner. This might feel like a very tight standard, but I would ask you to keep in mind that you're not working your way down from a 100% or 50% foreign ownership standard. You're working your way up from the zero foreign influence standard that is a strict reading of federal law would suggest. The risks addressed by this measure are not theoretical. Earlier this year, reporters used FEC filings to uncover $1.3 million in illegal foreign nations to a super PAC routed through APIC, an American subsidiary of a foreign corporation. And as a result, the Commission issued the largest penalty in one matter in the post-Citizens United era. Had that company, APIC, been required to sign the certifications required by the measure before you, their illegal behavior may well have been deterred. Again, I am delighted that the Seattle City Council is moving forward to address this key campaign finance issue at a moment when the federal government is unable to do so. By passing this ordinance, you will be doing not just Seattle, but also Washington and your country a great service. You will set an example that can be followed by others at the local, state, and hopefully someday federal level. I thank you for considering this measure. I thank you for the opportunity to speak before you today, and I welcome your questions.
Thank you, Commissioner. Really appreciate it. You have a tremendous record in chairing the FEC and in speaking very eloquently and clearly on what is otherwise an incredibly dense and complicated area of constitutional law. So I really appreciate it. And as a lawyer myself who practiced constitutional law for 10 years, it makes my heart go pitter patter as we're having this conversation, because I get to access a part of my brain that I don't always get to access as a council member. So really appreciate you being with us. Wanted to provide an opportunity for folks to ask any questions or provide comments to Chair Weintraub on her presentation. Councilmember Bagshaw?
Thank you. Thank you so much for joining us. I really appreciate it. I'm Sally Bagshaw. I'm a council member here. I'd like to ask you a little bit about your vision. I liked what you said about a corporation cannot have a right collectively that they do not have as individuals. What would you say, or how would you recommend us going forward to make sure that we are not in any constitutional violation if we are able to say or to do what you recommended, the 1% ownership or a combination of 5% ownership for multiple owners? How do we make sure that we're not running an unnecessary risk?
Well, I think that this issue has been resolved by the Supreme Court in some sense. The federal law contains a very broad foreign national ban on spending, and it has been contested. It was contested in very sympathetic circumstances, not by corporations, but by individuals who were living and working in this country from sort of friendly foreign nations, from Canada and from Israel, countries we consider allies. They had spent very little money. They wanted to print up some flyers at Kinko and hand them out in the park and make about $300 worth of contributions. And the D.C. courts, which were upheld by the Supreme Court in a decision by none other than now Justice Kavanaugh, said that those kinds of laws against foreign influence are constitutional, that they are consistent with other laws on the Constitution. In particular, in this Blumen decision, the court held over the last 4 decades, the First Amendment issues raised by campaign finance laws have been the subject of great debates involving all 3 branches of national government. This case does not implicate those debates. Rather, this case raises a preliminary and foundational question about the definition of the American political community and, in particular, the role of foreign citizens in the U.S. electoral process. And the bottom line is that foreign citizens do not have a role in the U.S. electoral process, and therefore they cannot have a role as corporate shareholders or in other ways that they might choose to route money into our elections.
Do you have a follow-up? Yeah, Councilmember Bagshaw has a follow-up question.
Thank you. How does that work with a publicly traded corporation? Especially, I think you know a little bit about what may have happened here in the city of Seattle in the last 3 weeks before the election, and a major corporation did invest $1 million 3 weeks before the election. And my real concern is, how do we determine whether there is foreign money? Do we go through each corporate structure? How does that work? Well,
you would be acting under your new provision. So it would act the way your provision lays it out, as looking to a percentage of foreign ownership in the corporation.
So I mean, let's just assume we've got one of these major corporations with millions and millions of assets. If there is any investor at all that is foreign, then that would suggest that that corporation could not participate in any way in Seattle elections?
Well, the corporation itself would have to certify that it met the definition under the statute of 1% or 5%, depending on which threshold you were operating.
Mm-hmm. And Lish, maybe you want to address the specific components of the draft ordinance that address Councilmember Bagshaw's question.
Yeah. So any corporation that seeks to make an independent expenditure or contribute to an independent expenditure committee would need to certify to the city clerk that they are not a foreign influenced corporation. And the definition of a foreign influenced corporation is one that has either a single owner that owns, that is a foreign national or foreign corporation, et cetera, that owns at least 1% of the company's assets, or a combination of owners who together control 5% or more of the company's assets.
So take a multinational corporation. We have many here in our region. And shareholders can buy and sell publicly traded stock. How would a company, and I'm just going to pick our local aircraft manufacturer as an example, would they have to affirm that the shareholders do not come from some other country? Because
Yes.
And with millions and millions of shareholders, or the shares are invested in mutual funds, how would one determine that? And I'm not suggesting that this aircraft company has invested in local elections. They don't. But what or how would they make that determination, should they choose to do so in the future?
So I looked at another major corporation in Seattle to determine whether or not they would have met the thresholds. And that's really outside of my area of expertise. But I think that that corporation had enough owners, either foreign mutual fund companies or individuals, that they were going to hit the 5% threshold. And it was pretty easy to determine at that level. They had at least one owner that was 0.89% of their assets was owned by one foreign individual. So I think they are able to know who owns their shares and can make that determination. And the city would not be in the business of making that determination. It's on the corporation that wants to participate in local elections to and make that determination.
Councilmember O'Brien, did you have a follow-up question?
If it's a publicly traded company, they obviously are going to know who owns all their shares, and so they will probably have way more information than the public might have. And if it's a lot of work and they don't want to do it, they can just excuse themselves from participating too. It's not a requirement. So it seems fairly straightforward.
We've crafted the legislation to place the burden and the onus on the corporations to provide a certification under penalty of perjury as to whether or not they are in compliance with the ordinance. Should they misrepresent that certification, then they would be subject to penalty of perjury. But I believe that Professor Coates might also be a subject matter expert in this particular space, and perhaps this would be a good opportunity for us to transition to him, to have him address this particulars around that question, Councilmember Bagshaw, which is a really good question. And then in the context of that, something that I think is that we get a lot of questions about is why the 1% or the 5%. To a lot of people, anecdotally, it seems like such a low number, and people are having a hard time, I think, understanding what exactly the degree and level of control and power actually is if you're a shareholder or a group of shareholders that owns either 1% or 5% collectively. So perhaps we can have our experts keep that in mind and help us understand sort of the practical aspects of how that functions in boardrooms. Professor Coates, would you like to go ahead and take over?
Sure. Can you hear me okay?
Yes, we can.
Great. So one more word of background about me. I used to practice corporate law in New York City at a law firm called Wachtell Lipton, which is a leading New York firm, and represented large public companies routinely in complying with regulations and laws of the kind that I'm going to be talking about. And this is the principal focus of my teaching and research. I'm going to very quickly sketch a couple of additional motivations for why this bill makes sense, and then I'll try to answer some of the practical questions that just came up. Beyond corporations, of course, can be of all kinds. Some of them are set up deliberately to avoid or evade detection in the campaign system, and I actually think that's an important starting point here. Foreigners, set up U.S. companies, which look on their surface like U.S. companies, but are really actually just conduits for foreigners. The foreigners donate money to those companies, and then companies show up as the formal donor to various other kinds of entities. They then dissolve, and the companies are really sort of used as transient ways to camouflage donations. So that's one thing to motivate a bill like this. A second is that even among public companies, which are subject to some kinds of disclosure obligations, of course, political activity is not one of those. The SEC and Congress to date have not imposed any meaningful disclosure obligations on large or small publicly held companies as to their political and investments and involvements, despite the fact that most large institutional shareholders think that politics is actually something that they think is investment relevant. Nevertheless, there's been a reluctance to do so. Foreign influence over U.S. companies, whether public or private, is growing. In a research study that Ron Fine, who's there at the table, and I and others did a few years ago, we found that nearly 1 in 10 U.S. public companies now have foreign owners that are holding not 1% blocks, but 5%, like big blocks, significant blocks, and that number has been growing pretty steadily over time. U.S. corporations that actually have 51% foreign owners control over 10 trillion, that's with a T, in assets in the United States. There are over 100,000 such companies that are filing actively with the IRS. So these are real businesses that are filing every year. And on those forms, they have to indicate their foreign ownership, and 51% and up, 100,000 of such companies. Overall investment by foreigners in U.S. companies of all kinds has been dramatically increasing from about 20 years ago, when it was 5% of all of the corporate ownership reported to the Federal Reserve. It's now over 25%. That's an aggregate. Of course, it varies from company to company. And that's just a reflection of globalization of investment. It's probably a good thing overall for the world that that's occurring, but nevertheless, it means that when you look at a company, even a company that seems as American as Budweiser, you have to recognize actually that's a foreign company. And foreign ownership of those foreign companies has been steadily increasing, and foreign ownership of U.S. companies has been steadily increasing. All right, so here we are. We're in a world in which companies are increasingly politically active, and foreign ownership of U.S. companies is increasing. So the main takeaway, and I'm happy to follow up if more questions occur to you after today, be delighted to help supplement any worries you might have. But the main takeaway is I've both in the St. Petersburg and on this one, I've worked with the teams trying to advise to make sure, from my experience on Wall Street and from teaching and working in the corporate governance area, that the law is practical and workable. And bottom line is, it is. The 1% threshold, let me just take that on, which might seem low, as was indicated by the council member. That's the same threshold that's already in place for guaranteeing a shareholder under federal law the right to put proposals to annual meetings of U.S. public companies. It's viewed as a very high threshold in the public company context, because actually 1% of U.S. public companies is a great deal of money. And for any one investor to have that much, if they are all diversified, that implies they have even more money. And so it's actually a relatively rare level for most investors to reach of U.S. public companies. And when they do reach that level, they're typically among the largest shareholders. They can certainly get the ear of the CEO or the investor relations officers of any U.S. public company, and even below 1%, if they're in the 0.5% to 1% range, and they put a call into the company. The fact that they can potentially get that level of influence means that they're going to get some engagement from the company. And that engagement often is meaningful in changing strategic direction and financing choices, whether to do a buyback or to invest, and how the company is managed. I should say that while the nationality of every shareholder of a company is changing on a daily basis, in the case of public companies, all 5% and up shareholders have to file very promptly, so that has to be kept current, and less than 5%, if it's more than $100 million of assets that are managed by that investor, that also is disclosed regularly with the SEC. In addition, the companies themselves have to keep relatively continuously accurate a list of their shareholders because they distribute dividends and they have to communicate and they have to elicit proxies, votes at their own meetings. And so from their own transfer agents and other intermediaries, they can pull lists of their shareholders relatively promptly. One question that was asked about mutual funds. The way the bill language works is you do not look through a mutual fund. So if Vanguard, for example, a fund I invest in because it's a good fund, invests in a public company, the fact that Vanguard may in turn raise money from lots of foreigners is irrelevant for purposes of the bill. Vanguard is a U.S. domestic mutual fund. It's managed and advised by U.S. people. The fact that they raise money at the mutual fund level would not change the dominant U.S. orientation of Vanguard, and so the bill would not look through the mutual fund. Okay, so that's one practical point. Another practical point is that the bill only requires what's feasible. So the certification is, upon due inquiry. So if unbeknown and unknowable to the management of the company, some foreigner had used some subterfuge, or there had been a rapid change in their 1% or 5% ownership, that would not create criminal liability or even civil liability for the company filing the certification. It doesn't allow evasion, so if the company knows this, that doesn't work, or reasonably could have known it, then that doesn't work. But if it's just a question of practical day-to-day changes, the bill takes care of that and would not impose liability. And then finally, to the point that we made earlier, of course, companies only have to confront this question if they want to participate in politics, right? So they don't have to. And when they are gearing up for that, that's not a casual decision, typically. It's something that's done with some preparation and forethought. And I'm quite sure already their lawyers are advising them about this because there are numerous statutes that regulate foreign ownership already outside the political sphere. So aircraft manufacturers, if they have defense contracts, have to worry about Defense Department regulations of foreign influence already. So this is a routine part of what large companies have to deal with. And I'll stop there.
Great. Thank you so much, Professor Coates. Really appreciate that insight. Any follow-up questions or additional questions for the good professor? Councilmember Bagshaw?
Thank you, Professor. Thank you so much for being with us today. Two adjectives that you used is that this law is both practical and workable made me very happy. Do you have any words of wisdom for us to reduce potential liability?
You mean the risk that someone could sue?
Successfully sue. We're familiar with lawsuits around here. The question is whether or not somebody could successfully sue us. And I just wonder if you have any recommendations on anything that should be added or things that we should know before we try to implement this.
I think you're already doing what needs to be done. That is to say, you're getting advice around the constitutional questions from experts like Commissioner Weintraub and the others around the table. You're getting some input from me about the practicalities of influence by foreigners and establishing that you have a record that shows that, in fact, there's a reason to believe, and there is, that if a 5% or a 3% or a 1% shareholder of a large U.S. public company is both foreign and wants to exert influence, they can. So with those two things in hand, I think you've got what you need to successfully defend any challenge to this law. As Commissioner Weintraub says, the standard is stricter for individuals, for non-corporate people, as we used to call them. And so the question is how much looser do you need to be for corporate business entities that are susceptible to foreign influence. And I think the levels that this bill establishes are reasonable. And they're consistent, just to say something I didn't quite say, the Business Roundtable and the Chamber of Commerce, admittedly in a different context, but nevertheless, are on record as saying that a 1% level is a significant enough level to treat those shareholders differently as a matter of federal law, and that they're important, and that is a critical threshold for understanding practical influence by shareholders. So the kinds of organizations that are, in the general set of those that might challenge the bill would have legally they'd have a hard time speaking out of both sides of their mouth on this, I think. So the short answer is I think you're already doing what you need to be doing, and getting other people to tell you that Commissioner Weintraub and I are not just making this up would be helpful, but that's probably the end of it.
Great, thank you so much. Any other questions for Professor Coates? Okay, we're going to go ahead and transition to speaking of people who might be able to confirm the theories that we just heard from folks on the phone. We're gonna shift over to real people at the real table who are going to talk to us about issues that are more specific to the super PAC question in particular. So we will go ahead and begin the process of transitioning back over here. I'm going to let Professor Altshuler go first because I understand you have a hard stop at noon. Okay, so why don't we go ahead and start with you, Professor Altshuler, and then we'll go ahead and go down the line if that's all right with the other presenters.
Well, thank you for the opportunity.
Madam
I'm
Chairwoman,
so sorry. Just
if
a
I
minute.
could interject for just a moment, if you all are done with me, I'm happy to remain available for any later questions that anyone has. But if you're transitioning to the group at the table, perhaps this would be an opportunity for me to thank you again and wish you well in your efforts.
Thank you so much, Commissioner Weintraub, for that gentle reminder. Yes, we are, I think, done with you folks on the video. For either of you, if you'd like to continue to stay with us to listen to the conversation, you're welcome to. But otherwise, you're welcome to hang up and we can conclude the video conferencing portion of today's committee hearing. I want to thank both of you for your expertise in this area and for lending us your expertise in this area. And you can rest assured that we will continue to be in contact as we develop this legislation.
Great, thank you.
Thank you so much. All right.
All right. Well, I appreciate the opportunity to talk about this pioneering and very important ordinance. My role, as I understand it, is not to discuss all aspects of the ordinance, but just to address the concern that limiting contributions to super PACs might be held unconstitutional. And when we talk about this part of the ordinance, I can't assure you that there's no risk of an adverse ruling. In a case called Speech Now Organization against the FEC, the U.S. Court of Appeals for the D.C. Circuit held that all limits on contributions to super PACs are unconstitutional. And soon thereafter, in Long Beach area Chamber of Commerce versus City of Long Beach, the Federal Court of Appeals for this part of the world, the Ninth Circuit, followed suit. But the U.S. Supreme Court has not considered the question. The Justice Department didn't seek review of Speech Now because, as Attorney General Holder explained to Senator Reid, it believed that the decision would affect only a small subset of federally regulated contributions. You can, if you like, put Holder's statement on a historic list of wrong predictions next to that of the Grand Ole Opry manager who told Elvis Presley to go back to driving a truck because he would never make it as a singer. Well, these two decisions have given Seattle a very strange system of campaign finance. Although Seattle voters have approved and the Washington Supreme Court has upheld a democracy-enhancing system of campaign finance that includes voter vouchers and sharp limits on campaign contributions, these decisions make evasion of the contribution limits easy. After making the maximum donation to a candidate, a person may give thousands or millions of dollars to a super PAC whose only mission is to support that candidate. So Seattle's limits don't restrict how much people can give to electoral efforts. They just require people to send their contributions to less responsible and more destructive speakers. Super PACs have been called the attack dogs and provocateurs of modern politics. The candidates don't have to take responsibility for what a super PAC says. These groups often disappear once an election is over. The ads they produce contribute to cynicism about politics, a cynicism that runs particularly deep among young people. Of course, the fact that these are doing negative campaigning is no reason to suppress them, but it's unfortunate that Seattle now has a system of campaign finance that actively channels funds towards less responsible speakers. No sane legislator would vote in favor of this system, and no legislator ever has. You folks certainly didn't do it. Seattle has this topsy-turvy regime, not because you chose it, but because some federal courts have held that the First Amendment requires it. Yet the thought that the Constitution requires it looks very strange, too. The Supreme Court held 43 years ago that contributions to candidates can be limited to prevent corruption and the appearance of corruption. According to the D.C. and Ninth Circuits, however, legislatures may not forbid multi-million-dollar contributions to super PACs because these contributions don't create even an appearance of corruption. The law currently says that President Trump might be corrupted by a $6,000 contribution to his campaign. That contribution remains illegal. But he can't be corrupted by the $50 million that Sheldon and Miriam Adelson are expected to give to a super PAC supporting his reelection. Not even the Speech Now opinion maintained that the regime of campaign finance it created was desirable or defensible. Instead, the court argued that a single sentence of the Citizens United opinion compelled its result. Supreme Court wrote in Citizens United, independent expenditures do not give rise to corruption or the appearance of corruption. And the D.C. Circuit said, in light of the court's holding as a matter of law that independent expenditures do not corrupt or create the appearance of corruption, contributions to groups that make only independent expenditures also cannot corrupt or create the experience of corruption. That's the whole opinion, in essence. And the first thing to say about this supposed syllogism is that it obviously isn't true. Contributions to super PACs can corrupt even when expenditures by these groups don't corrupt. Federal prosecutors have, in fact, indicted public officials for bribery because they've given favors or allegedly given favors in exchange for contributions to super PACs. Courts have upheld these bribery indictments. You can't escape a bribery charge by saying, please pay the money to my sister, and you can't escape a bribery charge by saying, please pay the money to my super PAC. Obviously, a contribution to a super PAC can corrupt. And notice that the indictments don't say that the super PAC itself did anything wrong. They don't say that its expenditures corrupted anybody. The super PACs weren't involved in the corrupt transactions, probably didn't know about them. Contrary to the argument of the D.C. Circuit, contributions to super PACs can corrupt even when expenditures do not. There's some other things to say about this opinion. One is that the statement on which the court relies was dictum, a non-binding aside. Another is that the Supreme Court didn't mean this statement to be taken the way the court took it. You'll find all those points developed in an article I wrote with Lawrence Tribe, the Loeb University professor at Harvard, Richard Painter, the White House ethics czar during the George W. Bush administration, and Norman Eisen, the White House ethics czar during the Obama administration. Eisen's the fellow you saw last week questioning academic witnesses before the House Judiciary Committee. You can find this, easily find my article online if you want to look for it. It makes other points. For 43 years, the Supreme Court has distinguished between contribution limits and expenditure limits. It upholds contribution limits very regularly, strikes down expenditure limits all the time. The court has offered 5 distinctions between contributions and expenditures. I'm not going to run through them all. You can find them all discussed in my article. But if you go through them the way the article does, you'll see that the contributions to super PACs just can't be distinguished from contributions to candidates whose limitation the Supreme Court allows. The ultimate question about posed by the Supreme Court's campaign finance decisions is whether super PACs create a sufficient appearance of corruption to justify that limitation. And our article has a lot about that, too. We describe public opinion polls on how corrupt everybody believes America is now, the views of Washington insiders, politicians on both sides talking about how corrupt super PAC donations are. I think we show that speech now has sharpened class divisions and helped to tear America apart. So in brief, this D.C. Circuit case was wrongly decided. I think the Supreme Court is likely to say so when an appropriate case comes before it. That case may very well arise if Seattle limits contributions to super PACs, and I hope you will. Seattle has led the way in combating the corruption produced by unlimited political contributions, and I think this city's mission is not over.
Thank you, Professor. In terms of your presentation, I have a couple of questions. One is on the expenditure versus contributions question. In your review of the ordinance as we've introduced it, do you have any opinions based on your review of case law and your expertise in this space? Do you have any opinions about how we've structured the ordinance in terms of this distinction between expenditures not being able to be potentially regulated, but contributions historically being able to be regulated if an interest exists to be able to do so?
The ordinance very carefully limits only contributions, does not restrict how much. A super PAC remains free to spend however much money it can collect, but it can't collect more than $5,000 from any one contributor.
So in your opinion, we've drawn the line pretty clearly between expenditures and contributions, staying away from contributions and really sort of squarely focused on contributions only.
Correct.
Okay.
Expenditures?
Staying away from expenditures and focusing just on a reasonable regulation on contributions.
Correct.
And then on the second thing, you mentioned a lot about how in your remarks, you talked about how nationally what the perception is of democracy as a result of contributions to super PACs. Is there any reason to believe that Seattle somehow is an outlier in regard to that sentiment, or is your review of public opinion and sentiment in this space pretty consistent across the country?
I think it's pretty consistent. I mean, you heard the public witnesses this morning talking about how discouraged people are, that they think their votes don't count anymore, that only money counts, and you will find that view expressed in national public opinion polls, and it's getting worse all the time. I mean, these polls show change over time, and greater cynicism about politics, greater discouragement about politics everywhere.
Any questions for Professor Altschuler or comments? Okay. Thank you, Professor, so much. And if you have to leave, please feel free to do. I want to thank you so much for all the work that you've done in this space and for my own personal copy of your article. I do have electronic copies of this article. Colleagues would be happy to circulate that, and we intend to make it part of our clerk file. So thank you so much for joining us and for making the journey out this way to be with us. So let's go ahead and move into the rest of our panel. We are running a little behind this morning, so I'm just going to ask that folks limit their comments accordingly so that we can be respectful of my colleagues' time and the public's time. Councilmember O'Brien.
I have to step out for another meeting, but this has been really informative and amazing, and I appreciate you, Chair, for finding so many experts from around the country to come weigh in on this. I apologize, I'll miss your comments, but I'll catch up with those. And I am thrilled that there appears to be a really solid path to move forward to continue to reform the potential for corruption in our elections, which is awesome.
And I just want to acknowledge that Councilmember O'Brien, who is finishing up his tenure, not just his term, but his tenure with us on the City Council, has been a champion of democracy reform efforts and campaign finance reform laws. I was actually a commissioner on the Seattle Ethics and Elections Commission at the time when Councilmember O'Brien asked the commission at the point to opine on a set of laws that would allow for publicly financed campaigns. That was the previous iteration to what we ultimately approved via honest elections. So you've been a huge advocate and champion in this space, and have been really humbled to be able to continue the legacy of your work, and look forward to the last touches that I'm sure you'll want to have on this legislation. So thank you for those contributions to our city.
Thank you so
much. Yeah. Okay, let's go ahead and move on.
All right. So the reason why I'm here, I'm not a legal expert. I run a local organization that focuses on democracy-related issues, voting rights, campaign finance reform, public funding of elections. In fact, we used to be Washington Public Campaigns, and we worked to help overturn the law that prohibited public funding of elections to open the door for the voucher program. We recognize that the voucher program, though, doesn't address the money coming in from outside, the independent expenditures, the super PACs, and we needed a way to address that. When I heard about the St. Petersburg Ordinance from John, was making a presentation at a national conference with some people from St. Petersburg, I said, why don't we do something like this in Seattle? Why don't we bring this to a bigger city to try to defend the vouchers? We were very concerned about the vouchers and wanting to protect that. And we know the onslaught of money coming in is undermining that. We know the voucher program is working. More people are participating. It opens the door for people to run for office that couldn't, but the money, we have to address the money. The vouchers were never supposed to do that. We have to come up with another solution, and that's why we wanted to bring forth this ordinance with the help of Free Speech for People. And then thank you, Councilmember Gonzalez, for championing this, because we needed somebody to get behind this to support it, because we know the public wants this. We hear all the time. We've done research in the state. Money in elections is a big issue people want to deal with, and we need to be proactive. Seattle has been ahead of the game in so many ways. I think we can be ahead of the game in this. So I really hope that we can get this through and set an example for the rest of the country. So thank you.
Thank you, Cindy, so much for all your work and for your collaboration and your partnership with us as we continue to work on this really important policy issue. Have really appreciated it. Any questions for Cindy before we move down the line? Okay.
I'll refer to Ron first.
Okay, great. Ron.
Thank you. I'm just going to make a couple brief but extremely wonkish points about the public interest or government interests that the council ideally would have in mind when considering this to make sure that they are the correct interests. So with respect to the super PACs provision, the issue there is the prevention of corruption, particularly quid pro quo corruption, and the appearance of corruption. And that is why the Clean Campaigns Act wisely limits the spending from independent expenditure committees, but not the, sorry, I said that backwards, limits the contributions to the independent expenditure committees, but not the spending from them. the prevention of circumvention of the contribution limits that are already in Seattle, the $500 maximum contribution limit, is also a factor to consider. But certainly, the council would not want to consider, for example, the exact nature of Independent Expenditure Committee's speech, what it is that they're saying, nor is it really at issue whether the super PACs are coordinating their spending with campaigns, but rather whether these very large contributions to the super PACs are causing corruption or the appearance of corruption or circumventing the basic contribution limits. That's a slightly different legal framework when we consider the provision about foreign influenced corporations and their political spending. Because there, as Judge, now Justice Kavanaugh has explained, there's a different public interest that can be considered, and that is democratic self-government and the preservation of democratic self-government. The issue here is not xenophobia. It's not about concern about foreign nationals themselves, and it's certainly not an opposition to foreign investment in U.S. corporations, but rather the extent to which a foreign-influenced corporation's political spending can threaten the preservation of democratic self-government. So I know that's a particularly wonkish set of points to make, but good. Yeah. But it will be important to have those in mind as the ordinance gets further considered. Thank you so much for championing this. It's a hugely important reform, and we look forward to working with you on it in the future.
I think, Brent, on the piece around foreign nationals and sort of where the genesis of that comes from, I mean, I think we're seeing a real life example of where that's coming from in terms of our national conversation around the impeachment trials that are happening in Congress right now, right? So we're being reminded as to why our U.S. Constitution is very clear that our government should be governed by the people of this country, and it is fundamentally about preserving our democratic process and protecting our Constitution and the principles and the values in that Constitution. And so I think that it's a really important point to make that this goes back from the inception of the U.S. Constitution and also is not driven by xenophobia or other anti-foreign national sentiment, but really it's about making sure that as we are considering these types of regulations, that we are squarely focused on getting back to the intent of the U.S. Constitution and forming a U.S. government for people of for the people of this country and for our existing democratic process. So really appreciate that reminder. Any questions for Ron? Great.
So I'll just
last but not least,
I'll just briefly say first to Council Member, thank you so much for your leadership and championing this model bill for Seattle and for the nation. Thank you to the committee members as well for being here for this discussion. I'll just bring us back to what Council Member Rice from St. Petersburg talked about at the outset. When we worked with her and other city council members in St. Petersburg, the focus there was addressing the threat of the flood of super PAC funding expenditures, as well as the threat of foreign influence corporate spending in St. Petersburg. Here, the issue is not the threat, it's here and now. Seattle is already experiencing this flood with respect to the corrupting influence of big money into super PACs and with respect to foreign influenced corporate spending. So the city is well suited dealing with the facts on the ground here to address this flood and to protect its democracy, and we're proud to be working with you on this model legislation.
Great, thank you so much. Any questions for our panelists or comments?
Just all of you, this is such an important step forward, and I really appreciate it. I didn't run this last election, but the 3 elections prior to that, it is hard to raise money. Mm-hmm. And especially if you're dealing with democracy vouchers, $25 at a time, that's a tough situation, but it's a right situation, something that we've really, we've respected. You had an opportunity, I think you both did, to get democracy vouchers during your campaigns. I'm interested in knowing a little bit more, when you worked with St. Petersburg, what lessons did you learn that we should know And probably if you've already been working with Councilmember Gonzalez on the legislation, it's already built in. But I'd love to hear from you. What did you learn, and what should we be paying attention to?
Well, we learned certainly at the outset how to make sure that the public understood these threats coming into the political process from big money donors to super PACs, as well as the vehicle of the corporate form for foreign influence in our elections. And I think in both instances, we were able to build a fairly large coalition to show that public support to the City Council. As Councilmember Rice said, unlike the situation here in Seattle, the City Attorney's Office there had a lot of concerns about the City Council moving forward with this. But the City Council members ultimately decided they needed to, as she said, do the right thing, irrespective of that concern the City Attorney's Office was presenting. We're happy the City Attorney's Office here seems to be very supportive of this. But I think that going forward, helping to explain to the public why these two threats to Seattle elections need to be addressed with this legislation will be helpful.
I have a sense that the public here has already responded with its votes. And what we saw 3 weeks before the election in polls and what we saw on election day, what was it, 11 percentage points apart? That is a big number. And I had many conversations with people that came up to me independently, not a question that I had asked, that just said they were so offended by the big money investment that they were going to vote contrary to what they had intended to, just because they didn't want to be told what to do. And I think that that's something that the corporations need to pay attention to. I hope they are, but getting the public really to understand too what we're trying to accomplish and threading that needle between Citizens United and the new cases that have been brought forward are going to be really important. So I look forward to any suggestions or advice you have as we're making the communications clear.
Great.
Thank you.
Thank you. Councilmember Peterson, any comments or questions?
Sure. So thanks for being here, and really want to compliment Councilmember Gonzalez on this, because besides this being a great idea, which I supported when you first developed it, it's the process you've gone through in terms of, it's sort of a gold standard for public policy making, I would say, because you've brought in national experts. You've looked at what other cities have done. You went to our commission and presented it and got those opinions and worked with local groups as well. So the amount of due diligence that's gone into this is incredible, in addition to it just identifying a gap and filling it. So I appreciate that.
Oh, well, thank you so much for saying so. We have been multitasking in my office, doing budget and other policy issues, and developing sort of the plan around the due diligence in the background and executing it, sometimes quietly, but deliberately, and so really appreciate your recognition of that hard work, and a lot of credit goes to my staff who has been exemplary in this area and just making sure that everybody is on board and ready and prepared. So thank you, V, for all the work that you've been doing on this.
Thank you, V.
And Brianna Thomas as well in my office. So it's always a team effort. So really, really do appreciate it. There is going to be more to come on this bill. This is a first briefing and discussion. Want to also really thank Lish for his efforts on on drafting, putting the draft together, making sure that we are dotting all the I's and crossing all the T's, and in your expertise in making sure that we are well staffed on this from the Council Central staff perspective. Really want to thank Cindy for bringing this issue to me in the first place. In October of 2018 is when we first had a conversation about what this kind of law could look like, and have really appreciated your guidance and your partnership in developing the legislation, and in making sure that the public, that our neighbors and people in our communities, voters who are impacted by big money in politics, understand what the bill is, and that we are continuing to build support. So really appreciate your grassroots efforts there as well. And then John and Ron, thank you so much for being our legal brains on many of these complex issues, and always being willing to talk to us on the phone. So I know that you are as equally accessible to any of my colleagues, and that you all plan to set up individual meetings and offer yourselves as experts in this space to make sure that folks feel like they have the right amount of information that they need to feel comfortable with this legislative package, and to have any sort of questions answered as folks may be considering potential amendments to the ordinance. So, and then just want to thank both of you for being here today. And, really, I think this is an opportunity for us, and it's been stated multiple times, to not just frame the conversation here at home in Seattle about how this really has an impact on how people perceive our democratic process, but also on the impact to voter suppression. There's a number out there that says that 26% of voters decide not to vote when big money plays into super PACs. That number is in the mid-30s when we're talking about African-American voters, low-income voters, and Latinx voters. So, and we also have heard numbers that 77% of Americans have lost faith that their vote even counts at all when we have a super PAC system like the one we do now, which is completely unregulated, unfettered contributions can come in at any point to these political action committees, and those numbers should be startling to us. And we have no reason to believe that somehow Seattle is an outlier and that we're some unicorn in this system of corruption, and that isn't a sentiment that people hold here. I do believe that people in Seattle want to see big money out of politics. We know that because they have overwhelmingly supported initiatives like Initiative 122, which is honest elections, and Initiative 735, which was the statewide initiative around getting a constitutional amendment of Return Citizens United. So we know that people here at home in Seattle and across the state feel very strongly about this issue, and it is a bipartisan issue across the ideological spectrum and political spectrum. There is wide support for a bill like this, and we have a real opportunity to again, not just frame up the issue and do the right thing here in Seattle, but hopefully inspire others across the country to also do the same. So really excited about the ongoing conversation, which will occur on December 19th. Here in Chambers again at 9:30 a.m. That'll be our first opportunity to really dig into issue identification and potential options for addressing those issues. And then we will break for recess. That will be the last committee meeting for my committee here, and we will break for recess as a council, and we will take the issue back up on January 7th, which will be a Tuesday. I think we're still working on a time. Based on folks' availability. And my hope is that we'll be able to get an amended version of the bill, if any amendments do come forward, out of committee on January 7th and in front of the new full city council that following Monday, which I believe is the 16th, 17th, something. 13th. Oh, God. Someday in which it is the 13th. For the viewing public and just for transparency's sake, I will not be here on January 13th because my baby is due on January 12th, and I'm just like lighting every candle I can possibly light in hopes that this baby won't come before January 7th. But we have a plan in place, and really excited that Councilmember Lisa Herbold has agreed to see this over the finish line if for some reason I'm not able to be here with you all, but we'll certainly be here in spirit if I can't be here in person.
Thank you. Councilmember Peterson said it very articulately and well, but Councilmember Gonzalez, this is champion stuff, and I appreciate what you've been doing, but also the way you've been doing it, and reaching out to St. Petersburg and hearing what they have done, the same issues we're facing. That was a really brilliant move. 2 years into this, they've not been sued yet, as people pointed out, likely since we're a little bit larger and have a target on our back sometimes. It's entirely possible we will see that, but just the way you've been going about doing this, extremely impressive, and I just want to say thanks.
Thank you so much. Thank you so much for that. We will also be putting together a clerk file to support our legislative intent and history here. So please, colleagues, keep that in mind as you are doing your own independent research and working with LISH. If you find relevant law review articles, news articles, other pieces of information that help us articulate not just the threat, but the reality of what's happening in our democratic process here. We are actively compiling that information to develop a clerk file that will join the passage of this council bill to really pin down the fact that we are addressing a real issue with a real solution to address those issues.
One quick thing, and this comes back, Ron and John, to your points. I really like the fact that we've got a Fordham Law Review. Is there anything from the University of Washington Law School or Seattle University that has been written or we could request to become part of the clerk file?
These are fairly specialized topics about which not a lot of people are writing, so I don't believe there's anything directly on point from one of the law schools in Seattle. I could look to see, but really Professor Altschuler and Professor Tribe have been at the forefront of this issue of taking on the super PACs issue, and in terms of the issue of foreign influenced corporations and their political spending, it is Commissioner Weintraub and Professor Coates. So these are the experts that we have here. That's not to say that there aren't people in the Seattle area law schools who couldn't develop that expertise as well, but so far it has not been, the issue expertise that has been there has not been from those particular schools.
Thank you very much for that. I think that just also underscores the work that you've done, is that you've got the national experts weighing in. You've got the people that are writing, as my contracts professor used to say, the book on this. And so I hope that we can build on this, but I really do appreciate the fact that locally we've got people who are weighing in and advising us as well.
We do have a professor on the East Coast who's done a fair amount of evaluation and analysis of our democracy voucher program. And so we've been in contact with her, and they've been doing research independent of this effort that's just part of the evaluation of the democracy voucher program, and we hope to be able to incorporate some of her findings in the reports. I'm trying to remember the name of the university.
Herwig at SUNY Stony Brook, is that it?
What is it?
Jennifer Herwig at SUNY Stony Brook?
Yeah, Jennifer Herwig, Stony Brook University? No?
It's a SUNY, State University
State
of New York.
University of New York. Jeez Louise. I'm like a sieve these days with information. So,
Can I just add that Professor Tribe did submit written testimony to the Seattle Ethics and Elections Commission in support of this bill, and he will be submitting written testimony in support of this bill before the City Council.
Right, yeah.
And we didn't mention it before, but the PDC also heard about this is in support of it as well.
The Washington State?
Yeah, the Washington State PDC.
Do we have anything in writing from them?
We do. We have a letter from them, and we also have a letter from the Seattle Ethics and Elections Commission. All of that will be condensed down into a clerk file. So we're hoping to be able to again, build as robust of a clerk file as we can. So as you all are continuing to ask questions and thinking about things, please feel free to flag some of those resources for Lish and my office so that we can incorporate it into the clerk file. We have a good little stack going already, but it always welcome to add more to that, of course. Great. Okay, if there are no other questions or comments, then we have reached the end of our agenda. I really appreciate y'all's flexibility. We're about 20 minutes over time, but really appreciate your flexibility and willingness to join us here and your ongoing engagement. So with that being said, this meeting is now adjourned.
Thank you.